Hello everybody. At first, I thought it would be best that I step away from the Harkles for a few days. But in the words of a very wise man, and you can find him on Instagram, Charles_voice_mail, and I'm using a bit of artistic license just to get away with it. Anyway, he said, no matter how long you step away for, there will still be a poo storm when you get back. So after a night of tossing about, I decided to face up to reality and work on my full response to Judge Warby's judgment. Charles_voice_mail also reminded me of Churchill's words, never give in, never, 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 in nothing, great or small, large or petty, never give in, except to convictions of honour and good sense. Never yield to force, never yield to the apparently overwhelming might of the enemy. We are the arbiters of honour and good sense, so we should do the same. Okay, so let us talk about Judge Warby's judgment, and I really beg for your patience, as I will start off once again with someone else's words, in the words of Benjamin Smallbrook, the following. I don't want to say I told you so, but I told you so. On January 19th, I wrote this. In the unlikely event that I was put in Justice Warby's position today, and having been honoured by Her Majesty the Queen with a knighthood, I admit it would have a bearing on my judgment. I would be only half listening to the case put before me, because my mind would already be made up. I would be thinking of the bottle of claret I'd be drinking when I arrive home tonight. I would be aware that the Queen doesn't want her family suffering more embarrassment in a media-frenzied court case, which could see Meghan Markle screaming across the courtroom at Thomas, her father. I would value my knighthood more than anything. It commands respect from others, it opens doors, and more importantly, it also gives me the best table in London's restaurants. I would put all of this at risk by upsetting Her Majesty, which is why I would never rule against a member of the royal family, whatever the circumstances. Of course, because I couldn't be impartial, I could never be a judge. I would put my own selfish interests first. If Her Majesty made it clear to me that she wanted to protect her family's reputation, that would be good enough for me. I have always said the Queen wouldn't allow this trial to become a circus. People should remember the case wasn't presented to a court, but to the royal courts of justice. Her Majesty is revered. She is the big boss and always will be. So there you go, in the words of Benjamin Smallbrook. And I found this again on Royal Archieholes. His words embodies exactly how I feel about the whole court case and its outcome, and exactly what I believe happened, and I'll tell you why I believe this to be true. In the very first place, this case should have come to an end months ago. You see, it feels good when you find out that you were right all along, but in this instance, it just makes me very angry, because I'm no lawyer, and thus the Mail on Sunday's lawyers and the judge should have known this, as it is basically Law 101 or law for dummies. Like I said, I'm no lawyer, and thus I'm going to give you my version in plain English, but I will read to you small portions of case studies. Just to reiterate, you see, this case should have been dismissed, suspended, or thrown out. whatever you say in your country. The first, or at the very least, the second time Meghan Markle changed her claim and or statements. The reason is that the basis of any civil case, or in the case of a personal injury case or claim, is the claim made by the plaintiff. There is no dead body, or medical records, or visible damage to property, etc. in a case like this. So, again, the case is based solely on the claim or claims made by the plaintiff. In this case, Meghan Markle. So when a plaintiff is found to have lied or exaggerated, there is no case left to fight, unless the defendant admitted to wrongdoing. I know it's not exactly the same thing, but I just want to illustrate what I mean by this. A simple example is where a guy on a bicycle is knocked from behind by a car. He falls, but the only visible damage are scraped knees and a damaged front wheel. The driver of the vehicle is shocked and nice and takes him to a hospital to be checked out. His knees are cleaned and bandaged. He's checked for other injuries and released. The driver also offers to pay for the repairs to the bike. So, at the end of the day, one would think all is well. Well, not always. A month, 2 months, 3 months later, the driver receives a summons to appear in court, as the cyclist now claims that the driver's recklessness had caused him loss of income, as due to his injuries he was unable to return to work and had subsequently lost his job. However, during the case, the defendant's legal team discovered that the plaintiff had lied to and deceived doctors and had in fact worked privately. So in reality, without legal jargon, at that point there is actually no case, as the whole case was based on the plaintiff's injuries and his ability to work. However, the parties and the judge cannot just gather their things and walk out. The defendant, in this case, the driver, or in Meghan's case, the Mail on Sunday, has to file a motion to dismiss the plaintiff's case with prejudice for fraud of court. And although I am now comparing apples with pears here and using a little artistic license, this is what the Mail on Sunday should have done. The first or second time Meghan changed her claims and statements. It is what they should have done when she finally admitted that she had allowed for friends and employees to share information with Scobie and Durant. But, you see, the Mail on Sunday were not interested in what was lawfully the right thing to do. No, firstly, they wanted to be right. Secondly, they wanted the drama and disclosures because it is advertising and puts them in the spotlight. Okay, and now for something even more serious. Affidavits or sworn statements are part of the discovery or evidence in any case, criminal or civil. And now I'm reading from United States law, but this is almost identical to what it states in the United Kingdom and even in South African law. The US description is just shorter. To lie in discovery is the most damaging thing that can happen, and they can be punished by the judge at trial. When the truth is discovered, the judge may impose a fine, assign additional litigation costs, or dismiss the case entirely. However, we are now talking about a civil case specifically. So I'm reading another piece from another document. Lying under oath, remember, an affidavit is a sworn statement, thus a statement made under oath. lying under oath is a crime. Although civil court has limited power to punish for perjury, the judge can forward the case to the prosecutor for criminal enforcement. Punishment for committing perjury could result in probation, fines, or a prison sentence. So will dear Judge Warby actually do this to Meghan Markle? I guess not. Okay, and let's even go further. I know I'm likely boring you by now, but if we do not learn, we cannot understand the full impact of how seriously we are being duped, and we'll also be unable to protect ourselves. Remember when Meghan Markle was asked to hand over all electronic communications? Remember how she and her lawyers just ignored the first two deadlines? Then finally, at the first hearing in January, they alleged it had all been deleted. The law is very clear on this. If the plaintiff does not give you the documents by the date specified, you can file a motion with the court, and it is called motion to dismiss for plaintiff's failure to comply with the court's order. Why did the Mail on Sunday's lawyers not do that? So folks, even with my limited knowledge and expertise, I can only deduce the following. Firstly, the Mail on Sunday's lawyers had 2 to 3 opportunities to file motions to dismiss the case, and they didn't, because they were 1. More interested in being right than doing the right thing, and 2. They also liked and found the attention and publicity beneficial. Secondly, the judge did not pay attention, as he had already decided in advance what his judgment would be. Judge Mark Warby is, after all, Sir Mark David John Warby, styled the Honourable Lord Justice Warby. Thus, there's no way in the world he was going to rule against a member of the royal family. And then please take note that Judge Warby received a promotion only this month to the Court of Appeal. So even if the Mail on Sunday should appeal, they will most likely get nowhere. And remember that he was appointed Lord Justice by none other than Her Majesty the Queen. Friends, I can go ahead and revisit Judge Warby's condensed judgment, but it is available online and I'm really not up to it. However, after having read it, it is clear to me that even the judge himself is not convinced of his own ruling, as he contradicts himself in at least 2 incidences that I could find without intensely studying it. I'm sure a good lawyer or someone with a keen eye and more interest could find more in those 5 pages. Even saying that Meghan had a reasonable expectation of privacy is just drivel, as how can anyone have a reasonable expectation of privacy if they had discussed the contents with staff, friends, and family, as she did by her own admission. Incidentally, I spoke to a retired lawyer before the judgment yesterday, and he too expected that the judge would rule in Meghan Markle's favour on one of the claims, but he expected the judge to rule in her favour on the copyright issue and not the privacy issue. You see, unless she had copied the letter word for word from one written by someone else, or had she used less than 20%, I think if I remember it correctly, there would be no copyright claim by anyone else. United States and United Kingdom laws apparently also differ on this. if I understand it correctly, in the United States, the recipient is the legal owner, but in the United Kingdom, the author is the legal owner of the content. So, folks, I believe that Megan will now withdraw the copyright claim and that there will be no court case. And if she doesn't, that she will win the copyright case as well. It does in any event appear that a hearing on the copyright will only be a formality to determine restitution and a few outstanding matters, as the judge is limiting evidence to that which strictly only has bearing on the matter of copyright. What I find particularly vile about the aftermath of yesterday's judgment is the gloating statements by Megan and her mouthpiece Omid, released soon after. Megan's statement is available online, but if any of you wish me to read it to you, I'll do so in another video. Let me know in the comment section below. So there you have it, my opinion. I do believe that both the Mail on Sunday and the judge are at fault as to the handling of the case, and I do believe that there was a little pressure from the palace to make this case go away. So you can shoot me for my opinion, but that is what it is. And now Megan had effectively been given the green light to lie and to shut us all up. What a world we are living in now. So my friends, next week I'll spend a bit of time on my other channel. I really need the break from the royals and the Harkles, but I'll also be completing a video I had been working on but decided to hold back about a month ago. I think this is the right time though to address a variety of subjects connected to the Harkles, but not necessarily about them. So, until we meet on the next video, take care and bye.